Hello, my name is Timothy Engelbrecht. I'm a partner here at Butler, Weinmuller, Katz Craig. As most of you know, Hurricane Matthew struck the U.S. last week with devastating results. Our office has been fielding calls from insurance companies with regard to Matthew, but also with regard to an issue that's popped up here in Florida over the last 4 years. That is the assignment of benefits issue. The purpose of this presentation is to walk through the assignment of benefit issue with you, to bring you up to speed on how the assignment of benefit issue may impact insurance claims here in Florida, and talk about a few legal issues that pop up with assignment of benefit claims. For shorthand, I'm going to refer to these sorts of claims as AOBs. The first question a lot of people have is, what is an AOB? What is an assignment of benefits? Florida law has recognized the ability of an insured to assign his or her benefits after a loss to another for approximately 100 years. In Florida, the typical way an assignment of benefits pops up in the insurance context is an insurance company will issue a policy to a homeowner or a commercial business, and after a loss, that homeowner or commercial business owner will hire contractors to either minimize the damage or repair the damage. When the contractor comes in to ensure that he or she gets paid, the contractor will have either the homeowner or the commercial business owner execute the assignment of benefits. The insured typically will say the scope of the damage that they'd like repaired. The contractor will agree to pay it, and when the insured executes the AOB, that gives the contractor the confidence that they will get paid because they can make the claim directly to the insurance company. Now, there are a number of front-end issues that pop up with AOBs. For most folks who have dealt with either a homeowner's or commercial insurance policy, you're aware that there's often a provision in the policy called an assignment provision or an anti-assignment provision. So the first question that we typically get from folks is, are AOBs legal? Are AOBs valid? My insurance policy has an anti-assignment provision. The anti-assignment provision in most insurance policies is there to protect the insurance company in the manner that they underwrote the insurance policy. What those policy provisions typically say is that you, the insured, are not allowed to assign the insurance policy to another without the written consent of the insurer. The purpose of this is to protect the underwriting integrity of the insurer. Here's an example. An insurer will accept an application from an insured, place a policy on the risk, and be confident that they've underwrote it and priced it properly. What that provision in the insurance policy is intended to do is prevent the insured from transferring that policy to a risk that wasn't underwritten. Florida law is clear that that anti-assignment provision does not apply to post-loss assignment of insurance benefits. So most policies that have an anti-assignment provision, that just prevents the policy from being transferred to a different risk, but it doesn't prohibit the assignment of post-loss insurance benefits. So let's take a common example. A homeowner has a pipe break in her house. She calls out a plumber or she calls out a water extraction company. That company comes to their house and will take an assignment of benefits to do the work. That contractor then will approach the insurance company and make a claim directly to the insurance company as though that contractor is standing in the shoes of the insured for purposes of payment. There's a number of uses of assignments in Florida law. They're not just germane to first-party property law. In the car accident world, we have personal injury protection, and assignment of benefits have been used there for decades with regard to medical treatment. More recently, we've seen the assignment of benefits being used in the first-party property context, mostly with water claims, pipe breaks, especially down in South Florida, but also for roofing claims and wind claims as well. One of the important things and what we counsel our clients initially on when you're dealing with an assignment of benefits is you have to understand what the document says and what it means. And one of the most important things that I can pass along as we're talking about assignment of benefits is it all starts with the assignment of benefit document. It all depends on the language that's in that document as to what the obligations on the insurance company will be, what the rights of the contractor will be, and what the rights that were assigned away from the insured are. An assignment of benefits does not have to be in writing. An assignment of benefits merely has to conform to contract law. That means that there has to be an offer, acceptance, and consideration. Typically, that's satisfied when the assignment of benefits includes language to the effect of, for and in consideration of the contractor's promise to do work at the insured or the commercial building's location, the insured agrees to assign benefits to the contractor to get paid from the insurance company. That's a very common type of assignment of benefits that we see. Some other assignment of benefit documents that are written up are less clear. Candidly, they can provide a lot of frustration for insurers as they try and understand what has been assigned, what has not been assigned, and how to handle that claim. Our recommendation is always, if you have a question as to what the assignment means and what your obligations are in handling that claim, reach out to us because we can help you with it. Some documents that are presented to the insurance company by contractors claiming to be assignment of benefits are not actually assignment of benefits at all. They might be what's called a direction to pay. Under those circumstances, the insurance rights have not been transferred from the insured to the contractor, but rather the contractor has received approval from the insured simply to be listed on settlement checks. That can create a whole host of problems if that's not understood at the beginning of a claim. So again, it's very important to understand what the document says and what the document means. Any assignment of benefits needs to be supported by consideration. Typically, that's supplied as long as the document says that the insured is transferring insurance rights and the contractor is promising to do work. Sometimes carriers will run into a situation where fewer than all of the named insureds have signed an assignment of benefit document. Let me give you an example. A husband and wife own a home, they have a loss, they call out a contractor, let's say it's a water extraction contractor, to dry the water in their house. Mrs. Insured is not home, but Mr. Insured is, and he executes the assignment of benefit for the contractor. And the contractor then presents that assignment of benefits to the insurance company. In this case, both Mr. Insured and Mrs. Insured are named insureds on the insurance policy. However, the assignment of benefits is only signed by one of them. This can present a problem because it's unclear as to whether that assignment of benefits is valid or invalid because fewer than all the named insureds have signed it. This is especially difficult when you're dealing with married people. Married people own marital property in Florida under a tenancy by the entirety. That means neither husband nor wife can alienate rights that they both hold without the consent of the other. Sometimes when only one named insured, especially a spouse, executes an assignment of benefits, if it's not signed by the other, it may not be enforceable. In situations where the spouses are estranged, that's particularly the case. And again, as you'll see in a theme through this podcast, when you encounter a situation where you're uncertain as to the enforceability of the assignment, it's important to reach out to us to assist you with that. There may be other situations where the assignment of benefits is invalid or it's unclear if it's invalid. If there's an assignment of benefits that has a transfer of the rights, that's typically called a bilateral contract. That's where the insured agrees to exchange rights, the contractor promises to do work. Some assignment of benefits are in the nature of a unilateral contract or a conditional assignment. In these situations, the insured promises to exchange rights, but only when the work is performed. These situations can raise problems for insurers, especially if the work has not yet been done and it's unclear if the work will be done. We've encountered situations where both the insured and the contractor are making claims for the same insurance rights, despite the existence of an assignment of benefits. Under these circumstances, there is a little bit of a conflict under Florida law as to how that's interpreted. Some case law supports the position that the way you determine whether an assignment of benefits is valid or not is by ascertaining the intent of the parties. meaning did the insured intend to transfer rights, and did the contractor intend to accept those rights in return for work. Another aspect of the law with regard to whether or not the assignment is valid does not focus on the intent of the assignment, but rather the plain language of the assignment. Under a recent case, the manner in which the assignment was determined to be valid or invalid was not the intent of the parties, but the plain meaning of the words in the assignment. There, the intent of the parties was irrelevant. You can see the way courts have approached it, the validity of assignment of benefits can cause challenges on the front end of these insurance claims. Because of that, again, if you have questions regarding the validity of assignment, it's important to have legal counsel at the outset of these issues, not at the back end after problems have occurred. One of the best probably practice points that I can share is if you have an assignment of benefit question, it's important to reach out to your insured, and it's also important to reach out to the contractor making the claim and try and figure out any questions you have before the claim decision is made. After it's made, it's tough to rework that if one side disagrees. One question that many insurance companies reach out to us on is if there's been an assignment of benefits and the contractor is now making a claim, what options does the insurance company have to seek additional information regarding the claim, either from the insured or the contractor? Most insurance companies are familiar with the post-loss conditions of their insurance policy that allows them to gather additional information after a claim. The classic example is an insured has a pipe break at their house, a lightning strike, a fire, water damage, and makes a claim. The insurance company needs to learn more about that claim, and they ask the insured to do a number of post-loss conditions under the policy. These might include an examination of growth, providing additional documents, providing proof of loss, answering questions, or a site inspection. The insureds are required to comply with those conditions in order to see their claim through. Insurance companies are often left wondering what they can do when the claim has been assigned and what they can ask the contractor to do. Under Florida law, a contractor does not need to comply with the post-loss conditions of the insurance policy unless the insurance policy specifically calls for it and the contractor agrees to do so through the assignment of benefits. Most contractors in the assignments they draw up do not require them to take on those additional obligations and burdens of the insurance policy. Instead, those conditions remain with the insured. So typically, although an insurer can ask for more information from an assignee contractor to tell a little bit more about the claim, the insurance company can really only require the insured to provide additional information. And there's sort of a two-step process. Although the carrier cannot ask the contractor to fulfill the obligations of the insurance policy, the insurance company can require the insured to fulfill those obligations. If the insured refuses, that would prejudice the insured's claim and probably give the insurance company a right to deny it. The insurance company would also have the right to deny any assignee's claim under the same logic. So the argument is if the insured fails to satisfy a post-loss condition of the insurance policy, that may bar the assignee's claim. The assignee does not have to fulfill those, but is subject to the insured's fulfilling of those policy conditions. Another question we get from insurance companies oftentimes is, my insurance policy contains an appraisal provision. So if the insured were to have a covered loss, and the insured and the insurance company disagree as to the value of that loss, either of the two, depending on the language of the policy, can request an appraisal. And the appraisal process typically works where the insured names an appraiser, the insurance company names an appraiser, the two appraisers name an umpire, and the agreement of any two sets the amount of loss. Under Florida law, appraisal is a favored mechanism for resolving disputes because it prevents needless litigation. So the question from many insurance companies is, if there's been an assigned claim and the contractor presents that claim and it's a covered claim, but the insurance company and the contractor disagree as to the value of that claim, can the insurance company or the contractor demand appraisal, and does the other party have to go? This has been a hotly litigated issue over the last 3 years. The most recent case law on this topic seems to suggest that once the claim has been assigned, either the assignee contractor or the insurance company can demand appraisal, and then appraisal would go forward as normal even though the claim has been assigned. The courts have said that this is not a duty or obligation of the insurance policy that remains with the insured, but rather an alternative means by which the assignee contractor and the insurance company can resolve the claim. Recently, there have been a number of news articles here in Florida regarding assignment of benefits, the number of assignment of benefits that have come up, as well as the impact that they're having on claims administration and litigation. For additional information on that, it's important to take into account the number of claims that have come up over the last 4 years, mostly in South Florida, on pipe breaks. And the use of assignment of benefits is most prevalent down there. It's important to remember, too, that here in Florida, we have an attorney fee shifting provision. In a nutshell, what that means is in a first-party insurance situation, if an insured has a disagreement with his or her insurer and needs to resort to the assistance of an attorney and ultimately prevails, that insured can make a demand for his or her attorney fees in addition to any recovery that that insured will make. So a number of insurance companies have reached out to us and asked us, on an assigned claim, does that attorney fee shifting provision also apply? And in Florida, it does. So if there's a valid assignment of benefits and a dispute arises and the assignee hires a lawyer and ultimately prevails, the assignee has the same right to request attorney's fees as the insured would. As you can imagine, this has created an incentive for contractors who are not satisfied with the outcome of their claim to request assistance of attorneys and helping them. This has created an explosion, frankly, in the number of litigated claims that we have in Florida involving assignments and benefits. It's very important to remember, as I said earlier, that the touchstone of whether an assignment of benefit needs to be handled in one way or another really depends on what the assignment of benefit says and the way the claim is handled in the beginning. That's the best way for an insurance company to avoid a disputed claim and a litigated claim. And that's why I, again, recommend if you ever have any questions on an assignment of benefits, it's best to seek legal counsel at the beginning of that claim rather than allowing the claim to go beyond without a clear understanding of what the assignment of benefits means. Another question we receive from insurance companies often is, can an assignee contractor file what in Florida is called a civil remedy notice of insurance violation if they think their claim is not being handled in good faith? The answer to that is yes. Let me explain a little bit more about what a civil remedy notice of insurer violation in Florida is. In a first-party property situation, if the insured does not believe that their claim has been handled correctly, they can file a breach of contract lawsuit. But separate and apart from that, they can also make a filing with the Department of Financial Services here, stating that they don't feel their claim has been handled in good faith. Once that form has been filed, the insurance company has 60 days to respond to both the Department of Financial Services and the insured. If the circumstances regarding the insured's complaint are not corrected within those 60 days, including the payment of the amount of money that the insured believes is contractually owed, the insured may succeed to a right to file a separate lawsuit called a bad faith lawsuit in Florida. The question many insurance companies have for us is, does that same process apply when there's been an assignment of the claim? And the answer again is yes. The statute says that any person aggrieved by an insurer's actions can file a civil remedy notice of insurer violation, including an assignee. And it's not uncommon to see an assignee file a civil remedy notice of insurer violation right before, with, or shortly after the filing of a breach of contract lawsuit. These are very time-sensitive issues, civil remedy notices of insurance violation, and if you receive one and have any questions as to how it should be handled, we recommend that you seek counsel immediately, because there are serious ramifications on the reporting and response time for that. In addition to the issues that are germane just to assignments of benefits, there's a number of issues that pop up when you have assignment of benefits in particular claims. Specifically, whether or not the insurance company can assert the policy exclusions when dealing with an assigned claim. And the answer to that is yes. When a contractor takes an assignment of the claim, the contractor takes it subject to all the defenses that would have been available to the insured had the insured retained the claim. As such, when the insurance company handles the claim, they have the full complement of defenses under the policy that they would if the insured had the claim. That includes all the policy's exclusions. In Florida, the burden is on the insurer to prove the applicability of any exclusion, including in an assigned claim. The assignee who's making the claim has the burden to prove that the claim is covered. A number of areas where we have seen assignee claims and particular exclusions apply is when there have been leakage or seepage claims. Most policies will include an exclusion for long-term seepage and leakage, and these are often pipe break cases that require water extraction contractors. Those claims are probably more difficult to handle than others because they require an assessment of the time that the leak occurred and the duration of the leak persisting. Those assigned claims can be even more difficult because many times the contractor has already performed all the work before the first notice of loss. Again, it's important to look at the assignment language and then handle the claim as you would as though the insured was providing it herself. In the big picture, those are the main issues that pop up when we see assignment of benefit claims. As we said, Hurricane Matthew has created an avalanche of claims here in Florida, and we anticipate many of these will be assigned claims. If you have any questions regarding assignments, how to interpret them, their validity, or questions during the claim process, please reach out and call us. We'd love to help you.